Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hi. Hello, my friends. Hello. Happy Thursday. Today's Thursday, November 20th of 2025. How's everybody doing today? Do a little afternoon stream today. It's currently 4:15 p.m. here on the East Coast. Well, I'm a little bit late because I accidentally went into the stream for tomorrow and I almost hit live on that one. And we already have a stream scheduled for tomorrow for the Karen Read civil hearing. That's going to happen tomorrow at 2 p.m. That's going to be a Zoom hearing. Karen's not showing up, I don't believe. I don't even know if she'll be on Zoom. And so it's not going to be a live and in-person stream, but it's going to be exciting, I think, because of the recent developments in the civil suit that Karen Read has filed against just about everyone that she claims framed her. That is in a different county. That's in Bristol County. And the case for, of course, the O'Keefes versus Karen Read is in Plymouth County. So I almost went live to that and then I had to back and whatever. You don't need the excuse. I'm sorry I'm late is all. And being late is one of my pet peeves. Yeah, I don't know why everyone's names changed, but it's been like that for a while in other people's chats where everyone's name goes to their like original username. I have no idea how to fix that either. I don't think it has anything to do with me. Trust me, if you wanted it fixed and I could fix it, I would fix it for you because I'm here for you. It's what I do. I aim to please. Well, I got some interesting stuff for you today. The first is the sidebar order from Judge Cannone, which we went over yesterday because it was buried into the stream that we were doing yesterday, might not have gotten the full attention that it deserves. And also, there is a stipulation that was entered into and filed with the court between Corri Hopkins and the Norfolk DA's office, which is basically an agreement about what's going to happen next. So we're going to take a look at that and I'm going to explain it to you. And then after that, I found a really interesting case. I fell into a rabbit hole and I found an interesting case. The trial's starting in February. It's in Essex County. It goes all the way back to 1986. Okay, I'm going to lay the deets on you. Or at least the deets that I have so far, because I just started digging into it. And what it looks like from some filings that I've seen, the guy who's being accused of murdering this girl in 1986, he wasn't arrested until like 2022. Apparently, what had happened was there were two cops who are potential third-party culprits who were never investigated. It's in the filings. It's in the papers. I'm not making it up. And I'm going to lay that one on you. And then you can fall into that rabbit hole with me and be collaborative like you are and find out more. And I think we're going to need to follow that one. Because also what I just found out as I was in my rabbit hole, and it was the very last thing that I did was go to the docket to find out who's going to be trying this case. And this, trust me, this was after I already got into it, after I'm already investigating it. The judge on this trial is going to be Kathleen McCarthy Nyman. I'm not making it up because I couldn't. So we're going to go into that afterwards. So you're going to want to stick around. Also, the briefs in Kelsey Fitzsimmons have been filed by the Commonwealth, but they are not yet entered into the docket. So my plan is hopefully I'll have those in my inbox, or they'll be scanned into the docket by tomorrow. And we can go over the Kelsey Fitzsimmons Commonwealth briefs tomorrow for the SJC. And then for the 2 p.m. show, because, we're not amateurs over here. We do 2 a days, like football practice in high school or college. We'll do the Karen Read civil hearing at 2, because it's Friday. And then who knows what else could happen on a Friday, because everything happens on Friday. As you know, we ain't got no quit. All right. Let's take a look for those of you who were with me yesterday. I don't even, I don't even remember what the topic of the show was yesterday that we were doing when we fell into this, or when this broke. So this broke yesterday while we were doing a stream on, hold on, because now I have to look, because now we were going over Bettero's new filing in Turtle Boy's case. And as far as I know, Kazi G has not surfaced. He has not filed any responsive pleadings or any papers. No response to the mega motion. His response was due on Monday. It is now Thursday. It's just the way things are in Massachusetts, my friends. There's no ramifications for behavior. Just kind of district attorneys do what they want. Don't turn over evidence, which is another thing we're going to look into in the case that we're going to discuss after this, from 1986, how the Commonwealth has been dragging its heels on discovery and not turning over things from 1986. Here it is. Justice Beverly Cannone issued an order yesterday while we were live, and we covered it in the middle of the stream. It's docket number 738 in the Commonwealth versus Karen Read case. And as you know, or just as a little bit of background, Corri Hopkins, the Queen attorney from North Carolina, filed a lawsuit against the Norfolk County DA's office because she couldn't get the sidebars from them pursuant to a FOIA request. So she filed a lawsuit. And she said, you're going to have to give them to me because that's the law. And they filed some, snarky responsive pleadings. And then they made Lally, I don't know if they made Lally do it, but Lally made a motion in the Karen Read case to clarify the impoundment order, probably at the behest of the district attorney that was responding to Corri Hopkins' pleadings, because it had never been done and they were unclear about whether or not those sidebars should be unleashed or released. And even though Damon Seligson, Karen's civil attorney, had made a motion to unseal the sidebars all the way back in July, that has still not been ruled on. And I guess it wasn't followed up on because nothing ever happened. So in any event, what Judge Cannone did, and this is exactly what I said she would do, if you've been listening to me scream into this microphone, is she issued an order on the Adam Lally motion, not on the Corri Hopkins motion, but on the Adam Lally motion. So Corri Hopkins filed a lawsuit, and then she made a motion. She didn't respond to that. She responded to Adam Lally's motion. She didn't respond to the motion filed by Damon Seligson, and neither did the Commonwealth. Listen, upside down, inside out Narnia of Massachusetts is where we are, specifically Norfolk County. And here's the order from Judge Cannone that she filed yesterday in response to Adam Lally's motion seeking clarification regarding sidebar transcript impoundment. The court issued the following order. It is hereby ordered that all sidebar conferences prior to both trials and occurring during the trials, other than those that discuss jurors or juror issues, shall be transcribed and made available. The court finds that good cause exists to extend the impoundment orders for all sidebar conferences that discuss jurors or juror issues. See Uniform Rules of Impoundment, Procedure Rule 3A. And so that was signed by Judge Cannone and so ordered yesterday, the 19th, right? Today's the 20th. And because of this order, the DA's office has entered into a stipulation with Corri Hopkins with regard to her case. We're going to take a look at that next. But it was my prediction that Judge Cannone, rather than even give Corri Hopkins the time of day, would respond to Adam Lally's motion and do it that way. And not that she would even have jurisdiction to respond to the other case, because that was in a different county. That was, I think, Corri Hopkins' case is pending in Suffolk County. But in any event, it seems that it has been settled. It has been settled. Here's the stipulation that was entered into in Suffolk County Superior Court, Massachusetts, not to be confused with Suffolk County, New York. It is a stipulation, which means it's an agreement between the Norfolk District Attorney's Office and Corri Hopkins, a way of resolving the lawsuit, kind of, because it's still gonna, you'll see that it's still gonna exist out there. And here's the stipulation that was filed with the court. This is a stipulation on plaintiff's motion for preliminary injunction seeking to enforce the public records law and defendant's response to complaint. Plaintiff Corri Hopkins and defendant Norfolk District Attorney's Office submit the stipulation and attach proposed order in connection with plaintiff's pending motion for preliminary injunction. And with respect to the Norfolk DA's office, response to plaintiff's complaint, and respectfully request that the court enter the proposed order filed herewith. We'll look at that quickly afterwards. In support of the parties' requested relief, the parties state the following. On September 25th of 2025, plaintiff filed a complaint against the Norfolk DA's office seeking to compel compliance with the Massachusetts public records law with respect to plaintiff's public records request for production of the sidebar trial transcripts from the criminal trials in the Commonwealth versus Karen Read. On September 25th, 2025, the Norfolk DA's office had responded to plaintiff's public records request, stating that the sidebar trial transcripts were being withheld based on impoundment orders entered by Judge Cannone in the Read case. On September 26, 2025, plaintiff filed a motion for preliminary injunction seeking to compel the DA's office to produce the sidebar trial transcripts. The parties agreed that the DA's office would have until November 10th to serve an opposition to plaintiff's motion, which was allowed by the court. The DA served its opposition papers on the plaintiff on November 7th. Plaintiff served her reply papers and filed the Rule 9A packet with the court on November 10th, and the court has set a hearing on plaintiff's motion for November 25th at noon. The parties also agreed that the DA would have until November 21 to serve its response to the complaint, which was allowed by the court on October 23rd. On October 28th, 2025, the Norfolk DA's office filed a motion seeking clarification regarding sidebar transcripts impoundment in the Read case, requesting that the court confirm the trial sidebar conference's impoundment status. Footnote 1, which reads, although the Norfolk DA's office motion was sent to the clerk's office on October 28, it was not ultimately docketed by the court until November 10th of 2025. I don't know. Did it fall off a desk somewhere? Did it fall off a desk somewhere, really? Because the clerk in Norfolk County is pretty good. But whatevs, blame it on the clerk, who took apparently 2 weeks to docket it. I don't believe it. The parties also agreed. Oh, wait, here we are. Footnote 1. In response to the DA's motion, on November 19th, 2025, Judge Cannone issued the attached order in the Read case, and that's the order that I just read to you. In light of Judge Cannone's order, the DA is in the process of reviewing the trial sidebar transcripts from the Read case in its possession for production under the public records law to comply with Judge Cannone's order concerning jurors or juror issues, as well as any exemptions from disclosure under the general law. Accordingly, with respect to plaintiff's public request for the trial sidebar conferences in the Read case, the DA agrees that A, it will not charge a fee to the plaintiff for producing the sidebar trial transcripts in its possession from the Read case. Well, let's keep going, because they do have some of them transcribed, and they do have trial transcripts. So they do have some of them transcribed, and I think others are going to have to be transcribed, like many of the pre-trial, both pretrial Preseason 1 and preseason 2, all of the sidebar transcripts from all of those motions hearings that we watched, which are going to be, some of them to me are going to be even more interesting than the ones during trial. For example, the one for the Rule 17 motion hearing where Jennifer McCabe and Brian Albert were supposed to turn their phones over, or there was going to be a hearing, but then all of a sudden the judge called off the hearing. Yeah, that was wild. I can't wait to hear those sidebars. Tell me in the comments what other sidebar transcripts from pre-trial you can't wait to hear. Hold on. Once the universe of the sidebar trial transcripts in the Norfolk DA's office possession are identified, the DA will advise plaintiff of the amount of time necessary to review and produce the sidebar trial transcripts and the date by which they will be produced. If the universe of records is so voluminous that they must be produced, hold on a second. Oh, wait a second. My cursor's over here. Okay, I'm back. If the universe of records is so voluminous that they must be produced in batches on a rolling basis, the DA will produce the first such batch within 30 days after the stipulation is filed. The DA will produce any subsequent batches within a reasonable time thereafter. To the extent that the DA withholds portions of the trial sidebar transcripts in its possession, subject to either Judge Cannone's November 19th order or an exemption under General Law Section 4726, the basis for each redaction will be identified on the face of the records through an annotation overlaying each redaction and in an accompanying cover letter. Given that the DA is in the process of producing the sidebar trial transcripts in its possession, the parties stipulate, subject to the court's approval, that the DA's response to the complaint is hereby stayed until a further order of the court. Scott says it could take years to get the entire volume of sidebars. Yeah, but there are a lot of them that we know that they've already transcribed from at least trial 2. And didn't, correct me if I'm wrong, and I know you will, didn't Hank Brennan order trial transcripts of the entire trial 1? Didn't he say that he read the transcripts for trial 1? I don't think he watched the trial. I seem to remember him saying he read the transcripts. And if that's true, then they already have the transcripts from trial 1. And so they may already have them. Team Brittany says, yep. He said he did. Yeah. Okay. So they should already have those transcribed, right? So maybe the things that need to be transcribed are going to be pretrial stuff and pretrial 2 stuff. Right. Exactly. In consenting to the stipulation, plaintiff reserves her rights to seek relief requested in her complaint by subsequent motion or proceedings, including the right to challenge any portions of the sidebar trial transcripts in the DA's possession that are withheld based on Judge Cannone's November 19th order or an exemptions from disclosure under general law for Section 726. My prediction is it ain't over. It ain't over till it's over because they're going to want to hide the ball and they were going to want to hide stuff. And there may be more fighting over things that are also they're saying or shouldn't be redacted that Corri may decide she wants to have unredacted. And so there is there. Yeah, the Kelsey Fitzsimmons brief has not been docketed with the court. I appreciate you trying to help, but it has not been scanned yet. And I do have access to it when it is scanned. But like I said, I'm going to go over that tomorrow. If the court grants the relief requested, it says the DA's office also reserves all rights and defenses with respect to the issues in the preceding sentence. If the court grants the relief requested in the attached proposed order, the parties respectfully submit that the hearing scheduled for Tuesday is not necessary, Tuesday, November 25th. So that's off the calendar. And then they ask that the court enter their proposed order, XOXO, Andrea Campbell, Attorney General, by Lisa Beatty, who's with the DA's office, Adam Stewart, Thomas Caldwell, and they signed Corri's name with her permission. So that is the stipulation. Stipulation is another word for agreement. And let's just take a look at the proposed order to see if there's anything that is different. While I pull that up, let's walk amongst yourselves for a second. And so in order to save the court time and energy, it is always very nice when attorneys draft a proposed order for the court. They like that. They don't have to do all the work. And so drafting a proposed order is a nice way of getting a judge to sign the order more quickly than having to draft it themselves. And this is the proposed order on plaintiff's motion. So they're submitting this to the court saying, please sign this. The judge, of course, can make any changes that the judge would like to make. And this is 3 pages long. Whereas on November 19th, let me just check the docket and see if it was signed. Or let me just scroll to the end and see if it was, I don't think it was signed yet. Whereas on November 19th, 2025, the plaintiff Corri Hopkins and defendant Norfolk DA's office submitted a joint stipulation in connection with plaintiff's pending motion for preliminary injunction. And with respect to the Norfolk DA's office response to plaintiff's complaint, whereas plaintiff's motion seeks to compel the DA's office to produce the transcripts of the sidebar conferences from the trials in the Commonwealth versus Karen Read, whereas the DA withheld the sidebar trial transcripts in its possession based on its position that the sidebar conferences remained impounded pursuant to Judge Cannone's orders in the Read case. Whereas on October 28th of 2025, the DA filed a motion seeking clarification regarding sidebar transcripts impoundment in the Read case, requesting that the court clarify the impoundment status of the trial sidebar conferences. Whereas on November 19th, 2025, in response to the DA's motion, Judge Cannone issued the following order in the Read case. It is hereby ordered that all sidebar conferences prior to both trials and occurring during the trials, other than those that discuss jurors or juror issues, shall be transcribed and made available. The court finds good cause exists to extend the impoundment orders for all conferences that discuss jurors or juror issues. See Uniform Rules of Impoundment Procedure 3A. Whereas the parties agree to the relief below in connection with plaintiff's motion, and whereas the parties agree, in light of their stipulation, that the DA need not respond to the complaint at this time, it is hereby stipulated and agreed by the parties subject to the approval of the court, and therefore it is hereby ordered that the DA will not charge a fee to the plaintiff for producing the sidebar trial transcripts in its possession from the Read case. And listen, it's going to be a lot of pages and it could be very expensive. That is something that they agreed to. When Corri, I think it was when Corri decided to allow them an extension to answer the complaint. I think she said, yeah, I'll give you an extension. And I'm not sure, but this is what I would have done. Yeah, I'll give you an extension if you agree not to charge me when you eventually have to turn all these things over. And that was a smart negotiation on her part, if that's what happened. The DA's office will produce the trial sidebar transcripts in the Read case in its possession pursuant to paragraph 8 of the stipulation. The hearing scheduled for November 25th is canceled. The DA need not file and serve a response to the complaint until further notice of this court. The court shall retain jurisdiction of this action for purposes of enforcing the terms of this order and resolving any remaining relief sought in plaintiff's complaint, with respect to which the parties reserve all rights and defenses. XOXO. Please sign it, Judge. Please sign it, Judge. Please sign it. So it sounds like, let's go back to, I already closed that out. They could start releasing them at any time, at the very latest, 30 days from now. But there are many that have already been transcribed. And so therefore, those should be, in my opinion, easy for them to turn over. They are going to be turned over to Corri Hopkins herself, the queen. Thoughts, questions, comments, concerns, and aside from TLR, who just says, Melanie, you're the best, in a super chat. Thank you for your super chat. I appreciate you. Salty comes in with a 20 and says, thanks so much for always breaking things down for us. You're the best. Oh, thank you so much. Any and all compliments are always appreciated. And Nicole Meredith gifted a membership. Thank you, Nicole, for gifting. You guys are the most generous bunch on the internet. And welcome to new members, Carrie and a photo. Welcome. Massdad is coming in with the hot tea. Says in general, this would be $2,000 plus. So a fee waiver is amazing. Yes. Yes, it is. I don't know if they charge by the page there or if they charge for time and page, but it would be very, very, very expensive. Very expensive. Because I know that she has requested certain just documents from agencies and they've charged her hundreds of dollars for those. And it is a win. It is a win. It is Massachusetts public record laws. Public records law. Thank you. And oh, sweetie, no. Gifted 5 memberships. You're the greatest. You're the greatest. Thank you. Thank you so very much. And look at the 5. Mass Dad, you got a free membership. Whoop, whoop. Over 50 Swifty. We love Swifty here too. We're a Swifty. I'm a Swifty. My whole family's a Swifties. Christina got one. Robin got one. And Deanna is sassy got one too. So welcome to the members. And thank you for your generosity. Oh, sweetie, no. Teresa says, tour hoodie just shipped in time. Oh, awesome. That's great. You're very welcome. Thank you for all I do. Thank you, Teresa. I'm glad that you got your tour hoodie. Norfolk County is kind of what I call it, Tushka, sometimes. Yeah, so I can't wait for Unimpound Town. I don't know how long it's going to take, but I know that they do have some that are already transcribed. They're going to claim that they have to, redact things. But listen, out of all the sidebars, and we know because Zoe is our resident statistician that there were 204 sidebars in trial number 2 alone. And how many of them had to do with jurors or juror issues? Not a lot. Probably a very tiny percentage. So that'll be interesting. And Boston Brandy says they wanted over $8,000 for my 4-day trial transcripts. Yes, it's expensive. Court reporters make a lot of money when people order transcripts. And that is true. That is true. That's a great question. And I just don't know the answer to it yet, but it is a great question. I've been wondering about it too. Scorp says, what about the juror that was excused from the first trial due to fanning? We won't get info on. Well, we may not get the juror's name, but I don't see why the circumstances surrounding the juror being released can't be redacted. I mean, the juror's name could be redacted, but I think we have a right to know. The public has a right to know the circumstances of that and the argument around it. And so it's going to be interesting. It's going to be interesting. Scott McGinnis is here, and he says that Massachusetts does have a sweeping public records state statute. Sort of funny. In such a corrupt state. Yes. Exactly. Oh, yeah. And right. There was a juror who had an issue with Paul O'Keefe during the second trial that he was staring at her or something, according to Turtle Boy. Yes, that is something also. Listen, there may be further litigation that Corri's lawsuit is not going to be discontinued. And there may be some further argument over what it is that is going to be released. But jury and jury issues, jurors and juror issues. Listen, there's a lot of arguments that can be made that we don't need to make now. But I think what we do is we need to just see what happens. We're going to need to see what happens. And there are so many other things that are so much more interesting than that stuff that I want to see that should have no problem being released and transcribed. So many things remember the motion to recuse before trial number 1? I don't remember if there were any sidebars, but now I'm going to have to go back and watch all my old streams. I have hundreds of hours on this case alone, all different playlists. Pre-trial 1, trial 1, post-trial 1, pre-trial 2, trial 2, post-trial 2. So many. This is not just from both trials. It is from also all the pre-trial motion hearings. So there were a lot of sidebars at those hearings, right? So we need to take the win. We need to take the win, right? And not worry about that other stuff later. That's what I'm thinking. But let me, hold on one second. go back to the stipulation just on my own screen for a second. I mean, the DA's office says they're in the process of reviewing the transcripts, so they have them. So they already have some of them in their possession. And all of the stuff that doesn't need redaction or doesn't need to be argued about redacting should just be turned over right away. They don't need to wait. But there's a lot of stuff that is not yet transcribed, and they're going to have to put the order in for that. And some of it could take a while. But it says in the stipulation, it says this. Once the universe, now we're in a universe. We're in another universe is where we are. Once the universe of the sidebar trial transcripts is in the DA's possession, once the universe of the sidebar trial transcripts in the DA's possession are identified, well, I think it could be kind of easy to identify them, the DA will advise plaintiff on the amount of time necessary to review and produce the sidebar trial transcripts and the date by which they will be produced. Okay, so they're going to look at them and then they're going to tell Corri Hopkins how long it's going to take and the date by which they will give them to her. And then it says, if the universe of records is so voluminous that they must be produced in batches on a rolling basis, the DA will produce the first batch within 30 days after the stipulation is filed. Stipulation was filed today. So at the very latest, the first batch will come out 30 days from now. So we can expect something within 30 days. And they can't come soon enough. And we're going to do a dramatic reading. And so many people have sent me emails wanting to audition. I was really just joking about auditioning because I think we already have some people, some other creators that are interested in reading the sidebar transcripts with me. I said, I want to be Judge Cannone. Emily C said she wants to be Hank Brennan. Thank you for your emails wanting to audition. I will keep them in escrow in case we need you. And in case you want to be on standby as maybe sort of like a why can't the words are just escaping me today. You know, an alternate. An alternate. Thank you, Melinda, for gifting 5 memberships. You're amazing. You're amazing. A lot of new members today. And it's Steph on the Cape says, bring on the papers. Bring on the papers. We did the papers already. If you just tuned in, you missed it. So just rewind. Didn't take us very long. And I don't know. Everybody's names reverted. Some people's names reverted to their real names. So they're Ginster Gold has been here for 9 months and says, I've been subscribed for longer, but happy 9 months to us. See? We're in it for the long haul, girl. We're in it for the long haul. Understudy. Yeah, the understudy. Thank you. Thank you, Patriotic. That's what I was thinking. Like when you go to a Broadway show and the understudy shows up. Just as a side quest for a second. I recently saw a Broadway show called Oh, Mary, and it's about Mary Todd Lincoln. It's comedy and it's really funny. And Mary Todd Lincoln is usually played by a man, but in the show that my daughter and I went to, it was a matinee. The understudy was performing, and they always let you know ahead of time. In fact, they sent us an email saying the understudy is going to be performing, and if you want to reschedule or get tickets for another day, you can. And I'm like, no, that's terrible. I want to show up for the understudy. I want the understudy to have her day. She was amazing, and it was great. So thank you for helping me with the words when I can't find them. Oh, Mary is amazing. It was really funny. It was really funny. All right. No, there is no, that whole thing that surfaced yesterday, and we're going to remove this comment, Joanne, but I'm going to answer your question. There is no truth to this rampant speculation yesterday about Jen McCabe being arrested imminently for intimidating Karina Kolakithis. All right. I'm putting that to bed right now. There is no truth to that whatsoever. Sometimes I think that the trolls release these rumors to see how far people will go with them and who will state them as truth. I don't know. It could be a trap. It is not true. It is not true. I felt the need to address that. So let's just stick to the facts and the papers. And it's okay that you asked, but I just want to put that to bed right away so that people don't keep speculating. I'm sure a lot of people were hoping it was true, but it was not true. All right. Are we ready to move on? I say yes. Unless you have any further thoughts, questions, comments, and concerns before we move on about the sidebar transcripts. Just the facts. Just the facts. Facts only, please, because this is really interesting. I want to know if any of you remember this. Just think of the order that I'm going to do it in, because I have so many thoughts about how to present this to you, but I'm going to present it to you like this. This is Claire Gravel. Claire Gravel was a 20-year-old girl who left Major McLeish's pub in Salem. Apparently, it's still in existence. Does anybody know about Major McLeish's pub in Salem? On June 29th, 1986, Claire Gravel was 20 years old. She went out to Major McLeish's pub in Salem with her softball team. She was a sophomore at Salem State College. She was out celebrating with her friends after a softball game, and a friend dropped her off at her North Andover apartment around 1:30 a.m. on June 30th of 1986. Oh, they're closed? Thank you, Hijinks, because the only articles I could find on this are old, and the old articles said that that pub was still open, so thank you for that. They're not open. Don't put that on your murder tour stop list. But it is in Salem. It was in Salem. This case is in Salem. This case is pending in Essex Superior Court. Claire Gravel's body was discovered the next day on June 30th of 1986 in the woods near Massachusetts Route 128 in Beverly. Does anybody remember this case? Nobody was arrested for the murder of Claire Gravel. She had been strangled until almost 40 years later. Almost 40 years it took for them to arrest someone. Crazy, you say? Yeah, kinda, but it gets a little bit crazier. So let's read the press release. There's a man now who's been accused of the murder of Claire Gravel. His name is John Carey. His trial is starting in February in Essex Superior Court. And the judge who is going to be hearing the case is Judge Kathleen McCarthy Nyman. Same judge as in the Kelsey Fitzsimmons case. And we've heard her. No, it's Carey, C-A-R-E-Y, John Carey. Are you ready for it? Okay. So here's the press release from the Essex District Attorney, August 24th of 2022, announcing the arrest of John Carey. Here it is. Suspect in 1986 murder indicted. And this was for immediate release on 8/24/22. And there's a picture of Claire. Salem, Massachusetts. This morning, an Essex County grand jury indicted John Carey, date of birth 9/3/59, for the murder of a 20-year-old North Andover woman in June of 1986. She was 20. Essex District Attorney Jonathan Blodgett announced. On Saturday, June 29th, 1986, Claire Gravel, a student at Salem State College, went to Major McLeish's pub on Washington Street in Salem with friends. She was last seen alive between 1:30 and 1:45 a.m. Sunday morning, being dropped off at her apartment on Loring Avenue in Salem. 3 workmen discovered her body in the woods on the northbound side of Route 128 in Beverly on the afternoon of June 30th. The medical examiner determined that she had been strangled to death. For 36 years, Claire Gravel's family and friends have had nothing but questions about her death, DA Blodgett said. Today, we are able to give them some of the answers. Over the years, investigators have interviewed dozens of witnesses and persons of interest and followed through on every lead and tip they received. A new lead developed in 2012, and assistant district attorneys, state police detectives assigned to the Essex DA's office, and Salem and Beverly police worked diligently to bring about the result we have today. Evidence recovered from Claire's clothing was instrumental in solving the case. Mr. Carey, 63, is currently incarcerated at MCI Concord for a 2008 conviction. He is presumed innocent and until proven guilty on the new charges. So this was the press release from August of 2022. Now, that's not all. Let me just close some tabs around here. Obviously, in 1986, they didn't have the same DNA testing capabilities that they have now, right? So I guess it took a while to get the DNA tested, but what the defendant is claiming is that there were other suspects that were cops that could have been responsible for the murder of Claire Gravel that were never, surprise, investigated. Here's a, I'm just like, I think I found one video. There's not a lot of information on this case that I could find. And being that it's Judge McCarthy Nyman, you can bet that there will be no camera in this courtroom. Oh, please. Another news article from Boston 10 said when the indictment was announced back in August of 2022, the prosecutors believed that she was strangled, but a motive was never identified. We continuously review cold cases, hoping that new techniques and a fresh look will result in a breakthrough, the district attorney said. We are mindful of the victims and their family members who continue to want answers. They are not forgotten. And then Carey was arraigned shortly thereafter. According to a random article that I found on Discovery ID of all places, it reads, Claire Gravel was only 20 years old when she was brutally murdered back in 1986 in Salem, Massachusetts. Her case remained cold until August 24th of 2022 when Essex DA Jonathan Blodgett announced that they had charged somebody with her murder. John Carey, a 63-year-old man who is currently serving a prison sentence for the attempted murder of a Hamilton woman in 2007, has been indicted, and it says indicated, but indicted for the murder of Gravel. Officers have been following this lead for over 10 years based on physical evidence recovered from Claire's clothing. It was her tank top that she was strangled with, and new forensic technology. At the August 24th press conference, Blodgett announced that a new lead first developed in 2012 with the surviving physical evidence. He said assistant district attorneys, state police detectives assigned to the Essex DA's office, and Salem and Beverly police worked diligently to bring about the results we have today. Diligently for 10 years? You had a new lead that developed in 2012 and it took you 10 years, and you're saying you worked Diligently? Well, I guess in Massachusetts standards, maybe that is diligently. I don't know. It seems like every case I look at in Massachusetts, I look at sideways now. And I know you do too. So don't hold it against me. But what I'm going to read to you in the defense motion papers for bail may shock you, probably won't, but it's interesting. Yeah. The Meowster chief says, if y'all want to be mad at anybody, be mad at the police stations that aren't testing DNA. Yeah, the crime labs. Blodgett, the DA, shared that Claire's father, Robert Gravel, had carried a photograph of his daughter in his wallet for 36 years. He added, we continuously review cold cases, hoping that new techniques and a fresh look will result in a breakthrough. We are mindful of the victims and their family members who continue to want answers. They are not forgotten. It is always, always, always about the victim, and my heart breaks for Claire Gravel's family. But based on what I'm reading in some of these papers, I'm not 100% sure that they've got the right guy. And I think that perhaps this is the case that we should follow. Let's look at the bail motion, which was filed in February of 2025, for some more details. So it is true. John Carey had been serving a prison term. I think he was in jail for like 14 years. He was in jail for like 14 years for the attempted murder of a woman in like 2007, 2008. And he was incarcerated at the time of his indictment. So he was already in jail. So he had no chance to get out on bail because he was in jail for another crime. You see what I'm saying? And so there came a time when his sentence was over and his attorney made a motion to say, listen, his sentence is over and he's not in jail anymore. So maybe he's eligible for bail. And we're going to hear a lot of the same arguments that we heard in Kelsey Fitzsimmons' case with regard to dangerousness and with regard to bail conditions. And let's take a look at them, because this is in the same exact county as Kelsey Fitzsimmons' case. Same judge is going to be trying this case. And I have a lot of questions. And this was filed all the way back, I believe, in February of 2025. I just got to pull up the docket for 1 second. Talk amongst yourselves for a second. I also have some other dates on this in my calendar, but as you know, remember the last hearing that we tried to zoom in on or even go on the conference call for, in which it was a male judge. It was not, and Tim Bradle was on the phone and they told him to go on the phone, and the judge was screaming at him that because there were so many people interested in the case that the Zoom, or not even the Zoom, it was like the phone lines crashed and they didn't have the capabilities, didn't have the technical capabilities to support all of the people on the phone call that wanted to listen to the case, right? So we'll go back to the upcoming dates at the end. This is defendant John Carey's motion to be admitted to bail. Hearing requested. His bail was denied, but I want to go through this just to give you guys some additional facts and things like that. The attorney for the defendant is an attorney by the name of Mark Booker, Booker. He's out of Fall River. I don't know if he's a public defender. I think he's a private attorney. Does anybody know Mark Booker or anything about him? I don't know. Let me know if you do, because I'm curious now. Now I have fallen down the rabbit hole. Call me Alice. Here, let's put Alice up in the corner, as we do sometimes when we fall into these rabbit holes. And I know you guys have, some of you have a lot of time, and you can dig into this for me and with me. So here we go. He was in jail for 14 years for an attempted murder. It was not a murder. Okay, let's go. In accordance with the constitutional due process rights guaranteed by the 14th Amendment of the Constitution, And Articles 1, 10, and 12 of the Massachusetts Declaration of Rights, John Carey, the defendant in the captioned matter, moves the court admit him to bail. In its findings and order regarding bail, including COVID-19 factors dated August 22nd, 2022, remember he was indicted in August of 2022, and this was October of 2022, this court, the judge's name was Tabit, T-A-B-I-T, ordered Mr. Carey held without bail by agreement. Footnote 1. On the date of Mr. Carey's arraignment, Mr. Carey's previous defense counsel filed defendant's stipulation to detention and waiver of bail hearing, premised on the proposition that Mr. Carey was then serving a sentence and would not be paroled before 2027, and the desire to avoid pretrial public recitation of the Commonwealth's allegations. Mr. Carey completed the sentence on March 1st of 2023, and Mr. Carey's wish to avoid a continuation of his already prolonged pretrial detention outweighs his desire to avoid pretrial publicity at the expense of his personal liberty. Therefore, to the extent that the court deems the stipulation to pose any form of impediment to admitting Mr. Carey to bail, Mr. Carey respectfully asks this court to relieve him of the burdens of the stipulation, where the rationale for it has evanesced. Well, I don't know who Mark Booker is, but I can't remember the last time that I saw the word evanesced in a pleading. Can you? E-V-A-N-E-S-C-E-D. The band Evanescence, by the way, because I think in song lyrics, and I'll allow it. They were a great band, Evanescence. Are they still around? And I looked it up for you. Evanescence. So evanesced means passed out of sight, memory, or existence. I'm here for it. Wake me up inside. That's right. You only call me when you're sober or something like that. Why don't you call me when you're sober, right? You never call me when you're sober. It was something like that. It was another great song. Anyway, there's your word of the day. Evanesced. It means to pass out of sight, memory, or existence. Vocab word of the day. And then they cite a case which says a court may vacate a stipulation if it's deemed improvident or not conducive to justice. So he's saying, listen, the other attorney before me entered into this agreement, but now my client's sentence was over in 2023. And so we now think that he should be eligible for bail. As explained in greater detail below, substantial evidence appearing in discovery produced to date has undermined the Commonwealth's case against Mr. Carey and pointed strongly in the direction of third parties as potentially liable for the decedent's homicide. Are you ready for it? This evidence shows that, one, the circumstances of this case have changed materially since Mr. Carey's arraignment and detention on October 21 of 2022. Two, a preponderance of the evidence shows that Mr. Carey does not represent a flight risk. And three, the Commonwealth cannot show by clear and convincing evidence that Mr. Carey's release on bail would pose a danger either to the public or to any individual person. A defendant charged with murder in the first degree has no right to bail, but may be admitted to bail in the discretion of the judge. The judge's exercise of discretion should not rest solely on a presumption against bail, but should be based on a careful review of the specific details of the case and the defendant's history. The judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weakness of the Commonwealth's case and the potential penalty of a sentence to life in prison. Remind me, because I forget things. Was Joshua Hubert in Worcester charged with first degree? Because he was out on bail for many, many years, remember? For the attempted murder. Well, actually, no, because she survived, so he wasn't charged with murder at all. Forget it, never mind. But he was out on bail. Remember, he threw the very young victim off the bridge and allegedly raped her? And he was convicted. Forget it. Further appropriate considerations include the defendant's family ties, financial resources, length of residence in the community, character and mental condition, and record of convictions and appearances at court proceedings or of any previous flight to avoid prosecution or any failure to appear at any court proceedings, along with the other factors listed in the general laws insofar as they're relevant. Okay, you know what I was thinking of though? Miles King. Miles King is charged with murder. I'm not sure if it's first degree, but Miles King was charged with murder. And because the Commonwealth, didn't turn over evidence and discovery for such a long time, he was recently let out on bail. Rosemary Scapicio is his attorney. And he was allowed bail because of the hiding of the ball by the Commonwealth. Dispassionate consideration of the weaknesses in the Commonwealth's proof, Mr. Carey's background and the customary bail factors demonstrate that A, by a preponderance of the evidence, Mr. Carey is not a flight risk, and B, the Commonwealth cannot show by clear and convincing evidence that Mr. Carey's release on bail would pose a danger to the public or any individual person. Argument. The law presumes Mr. Carey's innocence. Due process requires that every defendant, irrespective of the charge, receive an individualized bail decision based upon his or her specific circumstances. In Vasquez, the SJC reaffirmed that a defendant must be granted bail if A, the preponderance of the evidence demonstrates he is not a flight risk, and B, the Commonwealth cannot show by clear and convincing evidence that the defendant is a danger to the public or a particular person. The individualized bail determination may be made based on police reports, witness statements, probation records, and representations of counsel, provided that the evidence is sufficiently reliable to avoid any significant risk of an erroneous deprivation of liberty. Here, review of the totality of circumstances discloses that conditions of release exist that suffice to assure Mr. Carey's voluntary appearance at all court proceedings in this case. And here's the offer of proof. The patent weakness in the Commonwealth's case against Mr. Carey provides him with a strong incentive to appear voluntarily at all court events. First, it bears noting at the outset that in a reversal of positions frequently taken by prosecution and defense in first-degree murder cases, Mr. Carey has full-throatedly requested a prompt trial date, and the Commonwealth has resisted a trial date being set in the near term. That's unusual, right? Hold on. The case against Mr. Carey stands on a decidedly infirm forensic foundation. True, the Commonwealth has evidence tending to prove that Mr. Carey's DNA was identified on the tank top that the decedent wore. But nothing in the decades of investigation concerning this case has furnished any reliable evidence whatever that tends to establish any link between Mr. Carey and the decedent, much less Mr. Carey's DNA. Much less that Mr. Carey's DNA was deposited on the tank top during the commission of the crime. Footnote number 2, which says, and that was after he said the Commonwealth has not furnished any reliable evidence. Footnote 2 says, Mr. Carey anticipates that the Commonwealth will cite statements that he made in a post-indictment letter to his daughter or in a pre-indictment letter to his golf coach, suggesting that he interacted with the decedent in a pub the night before her disappearance. This is getting interesting. No forensic evidence or witness statements tend to corroborate these statements, which appear to reflect the desperate attempts by a presumptively innocent layperson to account to his family or friends for the alleged presence of his DNA on clothing allegedly worn by the decedent at the time of her death. By the time Mr. Carey made these statements, the Commonwealth's agents already had accused him of the decedent's murder, and while showing Mr. Carey graphic crime scene photos, asserted that, quote, that's your DNA on that murder weapon around her neck, which is her tank top. Is your interest piqued yet? I don't know. I see there's some breaking news about a tweet by somebody about the post commission. I don't care. I don't care about that right now. I want to focus on this right now. Thank you for the breaking news. I'll get to it at the end if I can, but I don't want to interrupt my flow and stop talking about this right now because I find this to be very interesting. Okay, here we go. Because of this, the Commonwealth is straining to formulate alternative identification evidence against Mr. Carey, consisting mainly of evidence obtained during an unrelated criminal investigation nearly 21 years after the decedent's death in this case. But since the outset of the criminal investigation of the decedent's death in 1986, the Commonwealth has had in its possession cogent evidence that points strongly in the direction of two different police officers employed by local police departments who participated in the investigation into the decedent's death: James Stapleton and Gerald Verrette, Verrette, officers employed by the police departments of Beverly and Salem, respectively. Consider Stapleton. Evidence far more reliable and concrete than the DNA evidence concerning Mr. Carey tends to establish a connection between Stapleton and the decedent's death. Stapleton was present in his Nissan truck, parked 50 feet away from the remote wooded area where the decedent's body was found, within 2 hours of the body being found. In August of 1990, Stapleton's ex-wife, who had been married to Stapleton when the decedent was killed, told police investigators that Stapleton, quote, "My ex-husband is very aggressive and volatile. He was physically violent and has a very explosive temper. He is just an aggressive person. I heard of complaints made to his police department regarding James being physically forceful with women he came into contact with." That was contained in paper number 50 about a Rule 17 motion. We're going to have to. Yes, that is true. Salem Officer Verrette died in jail for child rape. Thank you. Thanks, Chrissy the Crone. You stole my thunder, but I'm gonna allow it. What about Verrette, an officer who in 1992 pleaded guilty to raping a child during the period of 1982 and 83? Within hours of discovery of the decedent's body, police investigators questioned one of the decedent's friends, Julie Whites. Ms. Whites, who told them that, quote, Jerry is a police officer in Salem who, quote, used to ask the decedent out, and that the decedent never went out with him. When police interviewed Ms. Whites again on September 8th, 1987, she told them that Salem cop Jerry Verrette always bothered the decedent and asked the decedent. Okay, I'm back. That's not all. And those aren't my words. Those words are in the papers. That's not all. Defense counsel's continuing review of discovery produced to date has revealed additional evidence concerning the pall that Verrette cast over the last few weeks of the decedent's life. In the weeks before the decedent was killed, the decedent made handwritten autobiographical notes in a spiral-bound stenographer's notebook akin to diary entries. Yep, she kept a journal. And here's what's in her journal, folks. Verrette featured significantly in two such entries. May 23rd, 1986. Wednesday night, I was in such a bad mood, so I got absolutely hammered. Gerald did too. We were so drunk that Salem police officer Jerry Verrette was going to take us into PC. June 9th, 1986. We went to Majors to watch the Celtics game, then grabbed the bus to Boston so we could pick up Kelly's mother's car in Cambridge. We were feeling pretty good then after a few pitchers. Before we left, we ran into Jerry Verrette, who still wants to go out with me. Ugh. And he said he wanted to buy me dinner. Me, like a dummy, said yes. I told Kelly on the way home to say that her mother had cooked lasagna just for us, and I couldn't be rude and not eat it. He bought it too. When we got back to Majors, Jinxie was there. I was sitting with Jerry to be polite, and he asked me if I wanted to go for a ride on the Beamer. I didn't know what to do. How could I just get up and leave with a guy? Still, I wanted to go. Told everyone I would be right back and left. We rode over to Devereaux Beach and then went to Castle Rock. We sat on the rocks and talked. A while later, we left and went back to Major's. Jerry had gone when we returned. I was really glad. I'm sure he's mad, though. Tough shit. I will not go out with him. That's her journal. That was June 9th of 1986. She was killed on June 29th or 30th. Actually, I think it was June 30th. Her body was found. And after midnight is when her friends dropped her off. Was he mad enough to kill her? Footnote 3, which refers to Majors, says an abbreviated reference to Major Maglicia's pub, the sponsor of the decedent's softball team, and the last place the decedent socialized with friends before her disappearance and death. Footnote 4, after Jinxie, says, okay, a sobriquet for Michael Jinx, the decedent's ex-boyfriend, with whom she occasionally continued to interact romantically up to days before her disappearance and death. A sobriquet. We have 2 words of the day now. Sobriquet, S-O-B-R-I-Q-U-E-T, means nickname. I may be in love with this lawyer's writing, I'm just saying. These entries raise serious questions about the reliability of the police investigation, which the documentary evidence suggests ignored Verrette until his public separation from the police department, attendant to his being accused of child rape in around 1992. The Commonwealth's, here's the next section, is called The Commonwealth's Persistent Delays in Producing Discovery and the Attendant Forestalling of the Trial Warrant Mr. Carey's Release. The Commonwealth has dragged its feet in producing grand jury minutes. Footnote 5. The principal investigator on this case, retired MSP Detective Lieutenant Elaine Gill, formerly known as Elaine Condon, testified at grand jury in October of 2019. Mr. Carey's predecessor counsel never received those grand jury minutes or even notice that a grand jury had occurred. Dun, dun, dun. After several requests, present counsel received these grand jury minutes on December 20th of 2023, 14 months after Mr. Carey's arraignment in this case. Well, sounds like they held 2 grand juries. And the first one did not return a true bill. That one was in October of 2019. As you know, from all the cases that we're covering, prosecutors have obligations to turn over discovery. It's automatic discovery. And they never turned over those grand jury minutes and never even told his attorney, that grand jury happened. And we just looked at, but I've closed the window because I have so many windows open on my computer that it's causing a draft. The press release from the Essex DA stated, this morning, an Essex County grand jury indicted John Carey. Okay, this morning would have been August 22nd of 2022. Hiding the ball much? Same thing happened to Karen Reed and Aidan Carney when they convened a grand jury in Norfolk County to try and indict Karen Reed and Aidan Carney for witness intimidation charges or conspiracy to commit witness intimidation. And that was before, let's see, refresh my recollection, before trial number 1, because they seized her phone in January 2024. They convened that grand jury in the spring of 2024. They refused to return a true bill. And I think Karen's team didn't even find out that that had happened until something like trial number 1 was already ongoing, right? He's charged in Essex County as well. So it seems that they tried once in October 2019, didn't stick. They tried again in October 2022. That's when he got indicted. But it took them 14 months to get the grand jury minutes from the first grand jury. So the Commonwealth has dragged its feet in producing grand jury minutes. We just read that footnote 5. DNA-related reports, footnote 6, which reads, see paper number 2, motion to compel, filed on June 27, 2024. With the court's endorsement on November 13th of 2024 concerning production of DNA-related discovery sought in paper number 47, a discovery motion served in January of 2024, allowed without objection in July 2024. Let me just nutshell that for you. The defense made a motion in January 2024 for the Commonwealth to turn over DNA-related discovery, and they, like Cosgrove, just never responded to it. They never responded to it. So then the defense had to make another motion in June. And I guess there was no response to that either, because then, without objection, in July of 2024, the court ordered them to turn it over. And to this day, all of Mr. Carey's written statements, footnote 7. As discussed in greater detail below, the Commonwealth still, okay, and that this, when this was written, was 26 months after his arraignment, has not produced to Mr. Carey all of his written statements, instead withholding them and quoting from them to suit the Commonwealth's rhetorical purposes to Mr. Carey's prejudice, despite the dictates of Rule 14 and Mr. Carey's express written request for production. Are you surprised yet? Are you shocked yet? Where is Cosgrove? We don't know. We don't have proof of life. Goes on to say, a defendant should not be required to choose between the right to mandatory discovery and the right to a speedy trial. This principle applies even with even greater force, whereas here a defendant such as Mr. Carey is, at the Commonwealth's request, being held without bail. Then they go on to argue more reasons why the judge should consider allowing Mr. Carey out on bail. But the most important part of this, since the bail was denied, for our purposes today, is to glean more information on the facts and what was withheld from the defense and what still the defense can't get. The Commonwealth continues to withhold or drag its feet in producing rudimentary Rule 14 mandatory discovery, such as all of Mr. Carey's written statements, and to do so for prejudice. For example, in opposition to Mr. Carey's motion to suppress evidence derived from his computer, served in January 2025, the Commonwealth revealed in a footnote that, quote, a former golf coach of the defendant, George Jacobson, recently provided to the Commonwealth a letter the defendant sent him from prison dated June 12th of 2021. The Commonwealth's opposition quoted from the letter in pertinent part, quote, okay, now I have a very serious issue that I need your help with. Back in 2012, the state police came to me regarding the murder of a Salem State student, Claire Gravel. I met Claire Gravel after one of our Salem State outings in June of 1984, I believe. Well, that's 1984. She was killed in 1986. And as we're going to see, the defendant here worked in sports-related industries. But again, they didn't come to him until 2012. Again, this is a 1986 murder. And again, how dare they? How dare they? We have an emoji for that. How dare they quote a letter that they received from one of his buddies that was written by him before they even turned it over to the defense? Is that really the way things are done in Massachusetts? Yeah, kind of is. As of this writing on February 14th, 2025, the Commonwealth has neither produced a copy of the letter nor any writings that summarize statements that the witness, Mr. Jacobson, made to the Commonwealth's agents. And this is after this court, Judge Karp, already allowed a motion to compel production of discovery that Mr. Carey was impelled, another word, impel, IMPELLED, to file in the summer of 2024. Similarly, as defense counsel averred in an affidavit dated February 14th, 2025, the Commonwealth has spurned or impeded defense counsel's good faith efforts to conduct a court-ordered conference with the Commonwealth concerning the drafting of Rule 17 orders. Shocked. And the next section is Mr. Carey does not pose a flight risk or a safety concern. One moment. Mr. Carey was born in Gloucester. Did I say that right? Gloucester? Gloucester. Gloucester. Is a lifelong Massachusetts resident and is 65 years old. Aside from his convictions in 2008 arising from the non-fatal strangling of Rosemary Diskin, Mr. Carey has no convictions on his record. Well, it's kind of a big one. I don't know, I'm just saying. Mr. Carey's actions in the Diskin matter resulted from Mr. Carey's alcohol-fueled self-destruction. Mr. Carey has maintained nearly 18 years of sobriety. In parentheses, it says Gloucester. I did it right. Thank you. Had a little help. In parentheses, it says, after maintained nearly 18 years of sobriety, admittedly compelled by his continuous incarceration during that time. Before Mr. Carey's arrest in the Diskin matter, he owned and operated Field Goal Athletic Turf, a company he founded approximately 20 years before his arrest in 2007. The company installed or repaired ball fields at scholastic institutions all over New England. For 20 years, Mr. Carey used to officiate hockey games among players 8 to 20 years old. For 5 years, Mr. Carey taught golf to under 12-year-old students at Bass Rocks Golf Club in Gloucester. Mr. Carey has coached Pee Wee hockey, girls softball, soccer, and girls lacrosse in communities including Agawam, Braintree, Hamilton, and North Andover. Somebody in the chat must know this man. After Mr. Carey was convicted and imprisoned in 2008, hold on. He set on a course of intensive reflection and rehabilitation. During 13 and a half years of his 14 and a half years at MCI Concord, Mr. Carey worked walks and grounds. Mr. Carey improved the bleak physical landscape at MCI Concord by working to plant grass and 50 flower beds in areas of MCI Concord where there had never been so much as a blade of grass. The Commonwealth produced in discovery prison institutional records that verify Mr. Carey's participation in and completion of a host of programming while in prison, including the following programs identified and described in Massachusetts DOC description program, Alternative to Violence. And then they're going to go on for a couple of paragraphs to talk about what a great prisoner he was, model prisoner. He did all of these things. He's turned his life around. And so therefore, they should please let him out on bail. During Mr. Carey's first 2 years at MCI Concord, Mr. Carey attended one-on-one mental health counseling, at first once a month and then twice a month. And then he facilitated some support groups. He helped other people with their mental health and childhood trauma. Oh, so, well, it says here, Mr. Carey was asked to help facilitate a support group under the supervision of a licensed mental health professional that included other inmates who had suffered similar childhood trauma. Well, I guess we're going to find out that he's got some childhood trauma. I didn't see any mention of this in here before. He also served as the leader in the Catholic Church of Concord, provided mediation services, did lots of great stuff in Bible study in jail. During one entire calendar year of Mr. Carey's imprisonment in MCI Concord, Mr. Carey groomed and trained a black Labrador retriever, affectionately nicknamed Big Head Ed. Big Head Ed has entered the chat. He's a black lab, and he's an emotional support dog, to serve as an emotional support animal to a returning member of the armed services. Through the Emerson College Prison Initiative, Mr. Carey earned a bachelor's degree in media, communication, and sociology. And he tutored other prisoners. During Mr. Carey's current detention in the Essex County Jail at Middleton, Mr. Carey has for 2 years provided peer tutoring in the math department. And on and on and on. The Commonwealth also asked that he be evaluated as to whether he meets criteria as a sexually dangerous person, SDP, under the Massachusetts general law. Caitlin Peretti, PsyD, conducted the requested evaluation and issued a written sexual dangerousness consultation report dated February 8th of 2023. She opined that he is not likely to engage in future S-type offenses if not confined to a secure facility. Well, that's the Commonwealth's own expert who said he's not likely to reoffend. Remember, what he was convicted for was something that happened in 2007. What he's now being accused of is something that happened in 1986. And so they made all of their bail arguments to their very best ability, but still, Mr. Carey was denied bail. His attorney proposed a release on $25,000 cash, and the bail was denied. He even said, in addition to the $25,000 cash bail, will agree that he will remain out of and away from Beverly, Hamilton, and Salem, and would submit to GPS monitoring to demonstrate his compliance with these restrictions, that he would live in Marlborough, Massachusetts with his partner, that he will refrain from drinking alcohol, and if the court deems necessary, to submit to random urine screens to demonstrate his compliance. He wanted a hearing, and it was denied. And so he still is sitting, I think, in Essex County Jail. But the reason I bring that document to your attention is because it is one of the many documents on the docket, and it also gives us a little bit of an insight into what the defense might be with regard to 2 other potential suspects that were never even investigated. In fact, Verrette Gerald Verrette, who had been a Salem police officer, was convicted at the age of 46 in February of 1994 on 3 counts of rape and abuse of a child and 3 counts of indecent essay and battery on a child under the age of 14. He was at the time of his conviction, a former Salem police officer. He was a Salem police officer at the time of Claire Gravel's death. And he also, according to the papers that we just read, I got to go back to the actual paragraph. Hang on. Was in contact, according to the decedents, and according to Claire Gravel's own journal. She dissed him, and he got mad. In February of 1994, Jerry Verrette was sentenced to 3 years in state prison on one of the indecent assault and battery charges, and got a suspended sentence of 8 to 10 years on the other 2 assault charges, and a suspended sentence of 10 to 15 years. He's now dead, from what I can understand. I mean, I found an obituary for him, and it's the same name. I'm not exactly sure it's the same guy, but pretty sure it's the same guy. And the other police officer, James Stapleton, who was a Beverly police officer at the time, who just happened to be 50 feet away from where Claire's body was found within 2 hours of it being found. What say you? Should we follow this one? Trial is scheduled for February 2nd, 2026 in Essex Superior Court, Salem, in front of Judge Kathleen McCarthy Nyman. You just can't make it up. You just can't. There's going to be a status conference December 10th, 2 p.m. in Lawrence with Judge Karp, and then a final pretrial conference, Judge McCarthy Nyman, January 16th. And the motions in limine should be interesting, to say the least. And who knows what other discovery they still haven't gotten, because there's a lot of information. There's a lot of dockets. There's a lot of things that were docketed in this case that I just haven't looked at yet. But I just wanted to tease it a little bit with you to see if you want to cover it. That's the case of John William Carey, who was accused of the 1986 murder of Claire Gravel. They didn't solve it until 2022, even though they had leads in 2012. Interesting. Christina 090679 gifted 5 memberships. Thank you so much. And so did Michelle. Thank you, Michelle. That's another 10 new members today. Woo woo. Thank you. Clamasu says this was big news up here in New Hampshire, especially for college-age girls as we would go down to the North Shore. Yeah, back in 1986, right? Thank you, Suze. And her body was found right away. It's not like some of these cold cases that were, on Long Island where the bodies weren't found for, many, 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 many years. And Brigitte says, an hour behind, but a grateful I'm here. Thank you, Melanie. Thank you. Thank you so much. Thanks, Brigitte, for your 5 on top. Thank you for your super sticker. And Brigitte coming in with another 5 and saying, smash the like button. It's free. Thank you so much. And on top for your super sticker. So what happened, because I did a little more digging on this, and here's what happened. So what happened was, after his conviction in that 2007, 2008 case, his DNA went into CODIS. His DNA went into CODIS because that's a requirement, I think, in Massachusetts or in a lot of states, that once you're convicted, you have to give a DNA sample and it goes into CODIS. And so that is how they eventually made the connection between some DNA on her tank top, which she was strangled with, and John Carey. He is saying he may have come into contact with her, but he did not kill her. What had happened was, could be, I don't know. All right. So what is this? Oh, and Mrs. Profess says the Beverly police are extremely corrupt. Okay. All right. Cool. We're getting into it now. Now we're getting into it. If you live there, you know, right? If you live there, you know. I don't know anything about the McAlbert's civil attorney. I don't even know if that is even the McAlbert's civil attorney. It is some guy. First of all, whoever made a statement to the press on their behalf has not given a name. So there was a civil cover sheet with the name of an attorney on it, who I think was only on that cover sheet to accept service of process for them. I don't think that's really their attorney. I could be wrong. This attorney could show up tomorrow in Karen Reed's case, but it's unlikely, because the case in which Karen Reed sued them is a completely different case in a completely different county. And as far as I know, unless some attorney has come out and given a statement and attached their name to it, there's been no statement from any attorney with their name. So I don't know who that is. And I don't know that, in fact, that person even is their attorney. So, yeah, I have a lot of questions. I have a lot of questions. But I found it interesting that that attorney, whoever it was that shall remain nameless, because they didn't attach their name to anything in the media, that came out to say that the McCabe's and Alberts were going to maybe be suing Karen Read and Turtle Boy for defamation at some point in the future. That they didn't, first of all, they didn't attach their name to that statement. And second of all, that the very next day, Karen Read's civil lawsuit was made public. So in my opinion, that was a retort to them being served with that lawsuit because it had been served on an attorney on their behalf. You know what I'm saying? So there's that. There are a lot of people who claim to be attorneys or who act like attorneys who speak out for the McCabe's and the Alberts, who may not actually be attorneys. I have no idea. I have no idea. Let me go to, you guys said that Ted Daniels said something, so give me a second to pull that up. Of something that is of interest to you, that the Massachusetts Post Commission has responded to Attorney Alan Jackson's request to investigate Boston Police Commissioner Michael Cox's statements about former Officer Kelly Dever. Here's the letter. All right. Well, that was 5:10 p.m. What time did we go live? I don't even remember. 4:15? Look at us on the breaking news. All right. Let's take a look because we're here. Hold, please. All right. This is Ted Daniel from, I forget what channel he's with, Boston News Reporter. Says this: the Massachusetts Post Commission has responded to Attorney Alan Jackson's request to investigate Boston Police Commissioner Michael Cox's statements about former Officer Kelly Dever. Here's the letter. And this is November 20th. Oh, dated today. It's dated today. Via email only to Alan Jackson. This is from the Massachusetts Peace Officer Standards and Training Commission. It's a cold read. I haven't even read it yet. So we're going to read it together now. Ooh, that's bright. Via email only to Alan Jackson at Alan Jackson's email address. And there's Alan Jackson. Dear Attorney Jackson, on behalf of the Massachusetts Peace Officer Standards and Training Commission, Post Commission, I am responding to your letter of October 27th, 2025, regarding Boston Police Commissioner Michael Cox. In your letter, you requested that the commission, quote, initiate a full disciplinary review for dishonesty, lack of candor, and conduct unbecoming an officer under Boston Police Department Policy, Section 102. Under the commission's governing statutes, and as relevant here, a law enforcement officer includes any officer of an agency, including the head of the agency. The City of Boston has informed the commission that pursuant to the department policies and governing statutes, the Boston Police Commissioner is a civilian executive, not a sworn law enforcement officer. According to the city, Commissioner Cox does not personally carry out police duties and functions. Based in part on this information, the commission thus far has not required non-sworn civilian executives, such as Commissioner Cox, to obtain law enforcement certification, nor has the commission treated them as being subject to other statutory and regulatory provisions governing sworn law enforcement officers. However, the commission is currently re-examining its policies regarding civilians who are involved in overseeing law enforcement agencies. I'm sorry, isn't he also a police officer? Okay, so anybody can be, I guess anybody can be police commissioner. You don't have to be law enforcement, but he also happens to be, right? Okay. The commission thanks you for informing us of your views on this matter. Your comments have been influential with respect to the commission's ongoing refinement of its policies concerning the treatment of civilian authorities. Hold on. I think there's a page 2 to this. While the commission would ordinarily forward a copy of a complaint such as yours to the relevant appointing authority, the commission understands that your letter was also addressed directly to that person, namely Boston Mayor Michelle Wu, XOXO, Enrique Zuniga, Executive Director of the Post Commission, with a CC to Mayor Wu, Boston Police Commissioner Michael Cox, David Verrette, Boston Police Legal Advisor, Randall Ravitz, Post General Counsel, and Matthew Landry, Post Director of Standards. Zuniga, that reminds me of an actress who was on Melrose Place, Daphne Zuniga. Whatever happened to Daphne Zuniga? Now I need to know. Basically, they're passing the buck. I guess it's the mayor's problem, not our problem. We don't have jurisdiction over him because he's a civilian. So thank you for complaining, but not a whole lot we can do. And remember, Alan Jackson was the one who, Alan Jackson's complaint to them, I think was a demand. It was a demand for them to put Cox on the Brady list, right? That's what they're responding to. And so they're like, yeah, well, we're the Post Commission and we don't have any jurisdiction over him because he's not a civilian. So we really can't do anything. Sorry, bye. It just said super late to the stream and started from the beginning. I miss Major McLeish's. It was my favorite bar. My aunt used to work there. Wow. Yeah, they do. They have an answer to everything. They have an answer to everything they do. They actually do. And Aunt Bibi says, can I apply for the commissioner's position? I'll be asked, can't you see AJ mind spinning? I'll await AJ's response. Yeah, me too. Me too. Scott McGinnis says they're corrupt in your face. They don't care. They don't care. Well, nobody's suing him in Lemonade. This was really just in response to the, you should put Commissioner Cox on the Brady list is what you should do, right? Remind me if there was anything else that Alan Jackson complained about. You remember Daphne Zuniga, right? Yeah, he was a cop for 30 years. But, they're saying now he's not acting as one. I guess. That's what it sounds like to me. That was a cold read for me. So I'd have to do some more, homework on it and look up the statutes and stuff. But I don't feel like doing that right now. Sorry. I just don't feel like it. Right. And Leslie says, our lies says, I thought it said Leslie. In my opinion, Jackson knew this was going to be the response. That's why he also sent it to Woo. Woo, 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 woo. Dave Matthews, don't drink the water. Don't drink the water. There's blood in the water. Don't drink the water. Yep. AJ puts things on the record for a reason. Absolutely. Everything he says is very carefully scripted, as you know. I'm sure he didn't even expect a response. Alan Jackson didn't even expect a response. Pretty sure. That was the most non-comment comment ever. Yep. They don't care. You guys, they really don't care. He gives beauty for ashes as Carey claiming that the Commonwealth hid evidence and law enforcement was actually a better suspect before Karen, Aiden, and Kelsey's trials would have been unrealistic to me. Now, however, I think it's more plausible than not. I think you're saying what a lot of people are thinking. Clamasu says Mark Booker is Columbia. Oh, he went to Columbia undergrad and Columbia Law. Barred in New York and Massachusetts, 5 out of 5 on AVO, and super lawyers in Massachusetts appears to be highly regarded. We'll dig more later. Awesome. So you're saying he's a private? What you're saying he's not a public defender? Fairy Wing Butterfly, thanks for being here for a year. Says happy anniversary, Melanie. Thanks for your consistently exceptional work in presenting these cases. I just love being a cupcake. I love having you here, especially for a whole entire year. And Scott McGinnis pointing out that Cox won a huge lawsuit against Boston after he was arrested and profiled by Boston police, who didn't know he was a cop at the time, right? He was undercover. So Mayor Wu paraded him out there for political gains. Devin says, I think if you're 5, looks like a cop, and quacks like a cop, it's a cop. Thank you for your super chat. Thanks, Kim in Florida, for buying me 3 matcha lattes. She says, please don't spill. I appreciate you so much. I need it. I need all the caffeine I can get. Betsy, thank you for your Venmo. Says, never going to send through YouTube again. LOL, I love you with all my heart. Oh, thank you, Betsy. Thank you, Betsy. I appreciate you so much. All right, so they have 16 jurors seated on Walsh. Excellent. And that was as of close to 5 o'clock. So I know they only go 9 to 4. So if they have 16, they may stop after 16, or they may, well, tomorrow's Friday. She said that she was going to call the jurors in on Friday. So I didn't tune back in on Brian Walsh to see what Judge Frenier was said at the end of the day, if anything. And so I'm not sure if they're totally done picking the jury, or if they're going to try and get more than 16. You can let me know in the chat if you know. And that, my friends, is record timing. They started picking on Tuesday, 3 days to get 16 jurors. That's fast. Brian Walsh is going to be a great trial. You're going to want to be here for it. It's going to start on December 1st. And we'll be here gavel to gavel. Ashley Lawrence says, a year. Whoa. I know. Fast, right? I mean, this YouTube channel isn't even, well, a little over 2 years old. I think I started posting my own videos in something like July of 2023. 2 years and 3 months. And if you haven't hit the subscribe button yet, would you please do it? Because it's free. And because before we started this stream, we were only like 58 subscribers away from 130,000. So, you know, it would be a really nice thing to do. I think only 20% of you who watch my videos are not subscribed, but it is very, very nice and kind thing to do. And so if you wouldn't mind, that'll be super. We're 50 away, actually 50 away. We were 52 away and now we're 50 away. Smash the subscribe button. It's free. I did. Do you guys want to watch the interview with Bill Read? Bill Read did an interview yesterday with a local Providence station. If you haven't seen it and you want to watch it, I'll put it on. It's about 14 minutes long. It'll give me a chance to rest my voice. If you want to see the Bill Read interview and you want me to play it and go over it with you, put a 1 in the chat. I just have to find it now. I did watch it yesterday. Sure. Everyone's like, sure. Sure. Okay. All right. We'll do it. Like 14 minutes or so. I could even put it on a little bit higher speed so it'll be less. And he spoke to Channel 10 in Providence, right? That's a Providence station. It's a Rhode Island station. All right, let's do it. Thank you. Kimmy says that I have over 29 million views. Wow. I didn't know. Thanks for pointing that out. That's awesome. All right. Here's an interview that Bill Read, Karen's dad, gave yesterday to the Providence, I think it's WJAR. Reporter. And I'm gonna just, let's see, let me get the captions for you. And I just made it speed it up to like 1 1/4. This reporter doesn't show her face at all. The camera is focused solely on Bill Read the entire time. And here we go.
So Bill, tell me, I mean, since Karen's acquittal, how has life been for the Read family?
It's been in one way, a sense of fresh air, because the looming murder charge now, she's been exonerated from that. But, life still goes on. We're fighting this corruption. It's a battle. We will ultimately prevail. We will win. We've got the truth on our side, and an incredible body of lawyers who are passionately and enthusiastically involved in this case. So we go forward and with strength and faith, and this will get resolved. It's going to be a while, but it will be resolved. And Karen, everything that most people have a sense about in terms of the corruption in Norfolk County will be exposed. That's our belief. That's our hope. And that's what we're driving toward.
Where's
Yeah. Yeah. I mean, that seems to be the goal. I mean, listen, money is the goal too. And in my opinion, they can't write a check big enough to replace everything that Karen Read has lost. And that's the only thing that you can really achieve in a civil suit is money. You can't turn back the clock. You can't undo everything that's been done to you, but I don't think they can write a check big enough for her, in my opinion. And he wants the corruption exposed, and it will do that as well. It will do that as well.
That most people have a sense about in terms of the corruption in Norfolk County will be exposed. That's our belief. That's our hope. And that's what we're driving toward.
Oh, it will.
Where's Karen now? What's she been up to since?
Well, Karen travels a lot, and she spends an awful lot of time working with her attorneys, the local civil attorneys here in Boston, and of course, Alan Jackson out on the West Coast. So she's always on the phone. And with the 3-hour difference in LA time, it could be 7:30, 8 o'clock at night, and Attorney Jackson is still in the office. So, I mean, her days are full. She has friends. She travels up north to Florida, Martha's Vineyard, the Cape. And of course, she primarily stays here with his.
Who is this guy? This is Karen Read's dad, Dr. Bill Read.
My wife and her,
Keeping busy, per se.
Well, she's always busy. She knows this case inside and out, and she's reading all of the legal filings, and she is always in communication with the lawyers, and in a very positive sense in terms of guiding their thinking and listening from their perspective, what the legalities are in terms of the law. So it's an education for all of us.
How vital is Karen's legal team? I mean, would you have gotten to this point without them?
God, no. God, no. First and foremost, Alan Jackson. He's just, among a sea of great lawyers, he is one of a kind. His skill set, his passion, he's just inimitable. He's just matchless. And he's a great, great man. And we're so indebted to him for how he's fought tirelessly for Karen. And it's not easy when you're 3,000 miles away and you're traveling and you've got jet lag and everything. And plus he's got an inventory of critical cases out there in California and the like. So, I mean, I don't know how the man does it. I don't know, but we're grateful for him.
I don't think anyone's too surprised by the lawsuit. I mean, some people could have said they saw this one coming. What does your family hope comes from it?
One of the lawyers.
Oops, he has become America's dad. He has become America's dad. And to the viewer who's from California who didn't know who Bill Read was, I was just joking with you. This is Karen Read's dad. We've been following Karen Read trial for years and years and years since January of 2024. Let's see. He's going to say. The question was.
One's too surprised.
How the man does it, I don't know, but we're grateful for him.
I don't think anyone's too surprised by the lawsuit. I mean, some people could have said they saw this one coming. What does your family hope comes from it?
One of the lawyers, I think it was David Yannetti early on, said sunlight is the best disinfectant. And this will be the opportunity to depose many of these folks from the Massachusetts State Police and the like. And without the guardrails provided by the criminal prosecution in Norfolk County. So we are confident. We've got, again, fabulous lawyers, skilled, passionate, and working around the clock. You can be bright, well-trained, but you need a work ethic. And their work ethic is just beyond measurement, really.
You're feeling really positive about one person in particular who's kind of helping in your case. Can you kind of talk to me about that?
Lost in yesterday's news of the filing by Karen and her team, the 46-page document that's heavily grounded in evidence, the law, and the Constitution, and brilliantly drafted, was the announcement that this was in the local papers that a former federal prosecutor who resigned from his dream job earlier this month and was also, as reported, involved in the federal probe of the investigation conducted by Norfolk County into the Karen Read matter, has left his job with the U.S. Attorney's Office and has taken up residence, sold his residence, I believe it was in East Boston, and has taken up residence in Quincy, Mass, and will be challenging Michael Morrissey if he decides to run again for the position of Norfolk County District Attorney.
That's right. That's right. His name is Adam Deitch. He's announced that he's going to run for District Attorney of Norfolk County. He put a video out. We'll watch it after this. In quick fashion, the trolls were after him. I think he had to turn off the comments on his Twitter because they came after him. There were some marching orders, in my opinion, that may have been given out yesterday to attack this man, to make him think that he really doesn't want to be the District Attorney of Norfolk County. It's disgusting. It's revolting. And that's what goes on out there on the cesspool. I will play for you his campaign video when we break here, but he was the right hand to Josh Levy, who at the time that the FBI and the U.S. Attorney's Office was investigating the investigation of the murder of John O'Keefe, he was the right hand to Josh Levy. He knows all about this case. He knows everything that happened. He knows a lot more than you and I do. And the fact that he wants to run for Norfolk DA, praise be. It's also been announced that I think Michael Morrissey has decided that he is not running again. So there's that. And I hope he wins too. But, they came for him just like, we knew they would, maybe. I could have predicted it. I'm sure he wasn't ready for it.
And I can tell you personally, I am heartened by that news because I think this is an individual who probably has a rich perspective of what went on, and to leave his position with the U.S. Attorney's Office to come sell his house and come into Quincy, take up residence so he can be part of Norfolk County to pursue this position of District Attorney for Norfolk County. I couldn't be more thrilled. From what I know of him, I don't know much. I've never met him. I've only seen pictures of him in the local paper, but I know he's from your neck of the woods. He's a native of Lincoln, Rhode Island, graduated from Brown.
Oh, that's so interesting. Dr. Reed says he's never met him. He's never met him. But the Twidiots think that they're good friends, that they're dear friends. He says he's never met him. He's never met him.
From what I know of him, I don't know much. I've never met him. I've only seen pictures of him in the local paper, but I know he's from your neck of the woods. He's a native of Lincoln, Rhode Island, graduated from Brown, and I think has his Juris Doctor from University of Wisconsin. So we're just thrilled that the aspect that this man, Attorney Deitch, he's a prosecutor. He comes potentially into this position with prosecutorial experience. He's not a lifetime politician. So I just say to the residents of Norfolk County, get out there and vote. Please take back your government in Norfolk County. Get out there and vote.
Definitely important.
Yep.
Mm-hmm.
What do you think about the response that this lawsuit just furthers a fuel that this is a conspiracy theory?
Yeah. Oh, wait, hold on a second. I didn't realize I put this comment up here from Kimmy, who says, love him. He reminds me of my father. He was a strict, loving man. Yet Karen forgot who helped her. Alessi, Yannetti, the world. I don't know what you're talking about, but he does thank Yannetti. He says something about Yannetti. And I didn't mean to put that on the screen. I think I meant to put the one underneath it on the screen. So I do not agree with that comment. But there's that. He moved to Quincy. Yes, he did, Scott McGinnis. He moved to Quincy, the heart of DA Meatball Michael Morrissey Power, Meatball's home base. Yeah, how great is that? And then a hero comes along, says Kelly.
I don't know what else I can say. The truth will be told. The truth will come out.
Yes, they will.
And when it does, I don't think there'll be too many surprises. 95% of the population, not only in this region, but in this country, if not around the world, have, after 3.5 years of watching this, 2 trials of what Karen Read endured, they have a good sense as to what happened. I mean, you can't look at these trials, inverted videos at the Sally Port. John O'Keefe's shredded hoodie that was suggested it was done by when he was left to die on the lawn by being passed over by Karen Read's vehicle. And yet it was done by a technician at the Massachusetts State Police Lab. All of the witnesses whose testimony was questioned because of recanting earlier testimony that may have gone on during the first trial or in a federal grand jury, people are aware of what's going on, and it will ultimately come to pass. We will know everything that happened. Justice will be served. It'll be too much of an outcry for justice to just, all right, not be served.
Bill, what do you think is the biggest hurdle for Karen and her team going forward?
Stay healthy, stay strong, and they will. After 4 years this January, they have no quit, as Alan Jackson says, no quit. All the fight in the world, because it's a cause. This is an innocent woman who's been set up, who's been framed. This is a cause for justice. As an attorney, if you can't get behind this cause, you're probably in the wrong profession.
So you really think the biggest hurdle would be mentality and staying strong rather than anything legally?
Know the facts, and argue them skillfully, depose the right people. We'll win. We will prevail. There is no doubt in my mind.
How important has Karen shared this with you? How important it is for her to clear her name?
I think most people see her as being terribly victimized. We know she's been objectified in terms of some of the vile comments by the now disgraced and former trooper, Michael Proctor, who's since been fired. Karen lives within her own being. She knows she didn't do anything. I mean, true. I mean, she's lost 2 positions at Fidelity, at Bentley, had to sell her home, lost her vehicle, had to liquidate her 401, right? She's lost a lot. And plus, she's had to face the threat every day that this state was going to put her away for the rest of her natural life. And, when people say, how do you face that? She's a strong woman. My wife and I raised a strong daughter, but what she has become is largely on her own. We're so proud of her.
That's beautiful. You obviously have a long road ahead of you too. After coming out of a long road, really, yeah. The fight continues. How do you guys feel as a family? How do you move forward as a family? What's your advice there?
Well, to anybody who finds themselves in a situation, a dilemma that seems unimaginable, you have to have faith. I mean, we're a prayerful family. We observe our religion. We're faithful to it. And that's important for anyone. Our time on this earth is short. We're all mortal beings. And I think if you have that backbone of faith and trust in the Lord, you will prevail. It'll be sunny again. And it's sunny today. It's getting much better.
Anything else that you want to mention that I haven't asked you?
Thanks for the coverage. Thanks for the exposure. Thank you for keeping, this situation in the news. And, I suppose it's hard to not be in this news. I mean, the Karen Read saga she's a brand now. And we love her so much. And she's the most courageous individual I've ever met. Just proud to be her father, as my wife is proud to be her mother.
And she is fighting for not only herself, but people before her and after her.
Well, absolutely. There are people likely incarcerated who were not fortunate or blessed, as we have been in this case, to fight for the truth, to identify attorneys such as Alan Jackson, who can rally to the cause. And they're facing incarceration every day. And maybe some are facing no hope. So to the extent we prevail, and we will prevail.
You will.
That provides hope to those who maybe do not have any hope. And for those who are in the system right now and those who might be intended to do harm to innocent victims, it would be a wake-up call. Be careful. There'll be another Karen Read. And hopefully, all right, he or she will have the resources that Karen has.
I do have one more question. Your message maybe to anyone listed in that lawsuit. What would that be? What would you want them to know?
I heard this question. I was like, oh, girl, don't ask that. Like, why are you asking that question? Don't ask him to send a message. He has too much class for that, right? And I love how he says, we. This is a man who has undying loyalty to his daughter. Everyone deserves a dad like Bill Read. And everyone deserves a mom like Janet Read. And I've had the opportunity to meet them on 2 separate occasions. And they are the most kind and genuine people that you would ever want to meet. He is still in this with his daughter and for his daughter. And he will be until he takes his last breath. And everyone deserves parents like them. But I think that's a bad question. What would you want them to know? The people that you filed the lawsuit about? What if you had a message for them? What would it be? See what he says.
They already know it. I have no message to them, nothing whatsoever. The document speaks for itself. It's rich in details. The granular is thick. If you wade through it, you can't help but come away with a pretty good impression of what happened.
And any message for the O'Keefe family?
We're fighting for Karen, but also parallel to that fight is getting answers as to what happened to John O'Keefe. So you can't look at this as just one outcome. If we're successful, as I believe we will be, then we will ultimately know what happened to Boston Police Officer John O'Keefe. So that's how I look at it. I hope they do too.
Well said. Got nothing else for you unless you have something.
No, we're good. Thank you.
Thanks, Bill.
He is. He's a class act. He's a class act. Wasn't he also a professor? He should be a teacher. I think he was, wasn't he? I think he was. All right. Let's look at the video. Yeah. Adam Deitch's announcement video for his run that he intends to run for Norfolk DA. Oh, please. This is what his tweet says. My name is Adam Deitch. Until a week and a half ago, I was a federal prosecutor focused on public corruption cases, including right here in Norfolk County. If you want to restore competence, trust, and professionalism to our DA's office, then join me. And then he posted this campaign video. Let me know what you think.
Everyone deserves to live in a community where we feel safe, where we have trust in our leaders to serve with competence, integrity, and professionalism. My name is Adam Deitch. I grew up in a community with safe streets, good policing, and faith that those in power were honest, hardworking public servants. Until 10 days ago, I served as a federal prosecutor in Boston. I took on cases throughout Massachusetts, bank robberies, gun and drug cases, child exploitation, cyber stalking, and all kinds of fraud. But what I've spent most of my time doing is trying to root out public corruption in our state, including and especially right here in Norfolk County. I left my job in the U.S. Attorney's Office because when I see a problem, I want to solve it. Over the course of my career, I've learned that the overwhelming majority of police officers and prosecutors work hard and do the right thing. I've also been proud to stand shoulder to shoulder with members.
There's Josh Levy. There's a picture of Josh Levy. He was the head MF in charge during the time that they investigated the investigation into John O'Keefe's murder. I know. I hope the music is not going to ding me. But if you're on replay and this is cut out, just go to his website and I'll tell you the website and you can watch it there. Hope the music isn't going to screw me, but it could. I should have thought about that, but it's too late now.
Of law enforcement who work tirelessly to keep our streets safe. But I also know there can be grave consequences when they don't. I've seen firsthand what happens when police and prosecutors take shortcuts, rush to judgment, and then stubbornly won't consider other possibilities. That's what's been happening in Norfolk County for far too long. That's why I'm running for Norfolk County District Attorney as a prosecutor, not a politician. Norfolk County deserves leaders we can be proud of, who serve with honesty, transparency, and accountability. This campaign is about more than electing a new district attorney. It's about building a culture of accountability and integrity where professional police work protects victims, not insiders, and where we follow the evidence no matter where it leads or who it implicates. That's the standard I've lived by prosecuting corruption throughout Massachusetts, and that's exactly what I'll do as the next Norfolk County DA. Together, let's build a district attorney's office we can be proud of.
Right on. What do you think? He impressed me, and I don't live there. I'd vote for him, but I can't. His he's got a donation page up and everything. So if you just want to Google him, help elect Adam Deitch, Deitch, for district attorney. If they don't scare him away, because they're trying to scare him away. They're trying really hard. And I guess some people do get scared away by the minions, but we'll see. Yeah, I don't know. I noticed that too. That his beard makes him look a little bit like Alan Jackson. And Aaron says, do you think that's his looking similar to Aaron Jackson with the beard is merely coincidental? I don't know. It's a good look. I'll allow it. What do you think? Expert Architect says Cox put out a news brief a few weeks ago that they were refocusing on the 1800 cold cases. We were all like, 1800? It's got to be more than that, I would think, right? Thanks for your 5. Tracy says the word cop is derived from on the copper badges they used to wear in the 1800s. Thank you. From copper badges. Thank you for your 5, Tracy. Chrissy Mel says, we will get Adam Deitch elected here in North Carolina. I mean, if anybody can do anything, you guys can. You guys are amazing. And on top says, how beautiful and strong the words, wisdom, and truth of Dr. Reed. He's awesome. Well, yeah, I know. But somebody says, I think he had to turn off his comments. Somebody said, I don't see him being afraid of the trolls, but oh, you should see the comments. Should we go for the comments? Because the comments on this one seem to be still on. Do you want to go for the comments? I don't, because I don't even want to give these people like 30 seconds of my time. But all the usual suspects are in the comments like, hi, Adam, few questions. The witnesses in the Karen Reese case stated you displayed articles from Aidan Carney's blog while questioning them. And it just goes on and on and on and on and on. You can do it yourself. And then Jennifer McCabe's self-appointed best friend is in there. And there's a lot of people who are praising the Alberts and the McCabes. And it's what you would expect. So the comments are back on though, apparently. But it's just what you would expect. I'll put it that way. Okay. They're not bots. They're usual suspects, actually. They are the usual suspects. I don't think they're bots. But they've been out there for a long time attacking many, many, many people, including me. They're obsessed. Absolutely obsessed. All right. So here's the plan. Thoughts, questions, comments, concerns. Anything else you want to chit chat about before I break? Terry, thank you so much for my Cash App. She sent me a little note. She said, I'm sorry, I can't afford much. Listen, your presence is all that is necessary. I'm happy that you watch. I'm happy that you hit the like button, hit the subscribe button. It's free if you haven't already. And just you being here and being interested in the things I want to talk to you about is enough for me. I mean, really. I appreciate each and every one of you so very much. You have no idea. You have no idea. I don't know if there's a way you can filter the negative ones on the Twitter. I don't know. I know it's X. I don't care. I'm going to call it Twitter forever. Hate me for it. I don't care. People hate me for less. Doesn't make any difference. Okay, the Islanders are playing the Wings at 7 p.m. So Scott's got to go. So we're going to have to wrap. Tell me what else you want to talk about. We covered a lot of stuff tonight. I don't remember all of it. We covered, the sidebars are coming. The sidebars are coming. The sidebars are coming. I wish I had like a really cool, like, thumbnail. Like I could make cool thumbnails, but I really can't. I'm not good at that stuff. I'm not that creative when it comes to like arts and crafts and stuff like that. But like there's people on Twitter that like clip my content just to make fun of me. And I'm like, wow, you're like a pretty good video editor. If you weren't such a dick, I might even hire you to like clip my content for me to make shorts, but you're a dick. And then there's a fake TikTok account of me on TikTok. And that person is really good at video editing and I can't get TikTok to take it down. So I wrote a note to the person who's pretending to be me and said, listen, I would hire you to clip my content. You do really good work. But of course, they're probably a bot and they're not going to respond to me anyway. And so we covered the sidebars being released and Judge Cannone has ordered them released. Corri Hopkins has entered into a stipulation with the Norfolk County DA's office that they are going to do so. And they're going to start releasing them maybe in batches. They have to do their redactions first about the things that Judge Cannone said have to be redacted, like the jurors and the juror issues. And we talked about that. So we should start seeing some sidebars soon. And then we're going to do a live dramatic reading. It's in batches because there's a lot. There's 204 sidebars alone in trial number 2. And then we talked about the upcoming trial of John Carey, who is being accused of the 1986, that's right, 1986 murder of Claire Gravel. Let's put Claire's picture up again. May she rest in peace. Claire Gravel from North Andover. She was killed in Salem after a night out at Major McLeish's pub in Salem after she was celebrating with her softball team. And according to the defense of John Carey, there were 2 police officers who are third-party culprits who may have been the ones to kill Claire Gravel. And we looked at the reasons why as set forth in his bail motion. And you can bet he's probably got more evidence than we saw in those papers. That trial is coming up in February in front of the very one and only Judge Kathleen McCarthy Nyman in Salem in Essex County. She's the one who put Kelsey Fitzsimmons back in jail, where Kelsey Fitzsimmons still sits. As far as I can see, Kelsey's briefs, the Commonwealth briefs, have not hit the docket yet. I can't access them yet. They were filed today. I know they were filed. I just can't access them yet. The Commonwealth briefs for the full SJC panel. Tim Bradel, her attorney, Kelsey's attorney, has asked that they start looking at it right away, like as in tomorrow. So if I have those briefs by the morning, that will be the morning stream. We will read together the Kelsey Fitzsimmons appellate briefs that were filed by the Commonwealth. And then for the 2 p.m. stream, we will be heading on over to civil court in Plymouth to cover Karen Read's civil Zoom hearing. So thanks for hanging out with me tonight. I appreciate you more than you know. We've been together for a very long time. And thank you, Blessed Mom from Texas, who says, I absolutely love you. That's all. That's all I allow it. For 18 months, well, I've allowed it. This is a short one tonight, only 2 hours. But, you know, the Islanders are playing and Scott needs to get in front of a TV. And I try and do everything that I can for my mods. Thanks, you guys. When I end this, I've already set up a teleportation for my stream tomorrow on Karen Read. So you can hit the like button. But if Nurse Kim is going live, then please go watch her. So this will teleport you over to the Karen Read civil trial hearing tomorrow. So you can hit the reminder and then come back tomorrow. And then please go watch Nurse Kim. What time is she going on? Buckle your seatbelts. I'll teleport you. And thank you, love from Tejas. Says, motion to nickname Adam Deitch DA Daddy in jest. I'll allow it. Bill Reed, thank you. Mel, love you. Yvette and Michael. Thank you, Yvette and Michael, for your 20. I appreciate you so much. Nurse Kim is going on at 7, so you have a half an hour to go get a snack, get hydrated. Thank you, love from Texas or Tejas for your 20. And buckle up, buttercups. I'm going to send you over. Thanks, mods. You're amazing. I couldn't do this without you. And you're the greatest. And I know that you're new here. California Info Warrior, except we don't allow cop bashing of all cops, because one of my best, you got to me before you. We don't bash all cops here. We don't do that. I'm going to give him another chance. Scott, because he didn't know. It's his first time here. All right. I'm going to give him another chance. We don't bash all cops. Nobody hates a bad cop more than a good cop. So we don't bash all cops here. Okay. Not all cops are bad. Just like not all lawyers are bad and doctors are bad and other people are bad. Thanks. Mods, I love you with all my heart. I love each and every one of you for watching. Do all the things that YouTube likes. You know what they are. You gave him a chance? All right. We're going to have to keep an eye on him. I know we will. Detain him, Scott. Block Island is getting crowded. Don't forget to like before you go. Love you guys. Buckle up. And I'll see you tomorrow. Bye.